Hopefully you can still hear me. And okay, so today we are going to talk about ballot initiative number 58, which is on, it's called the Natural Medicine Health Act, which would basically decriminalize small possessions of plant-based substances, all natural, and then a couple of fungi like psilocybin and but so I will give you which substances in particular. One of them is pronounced
ibogaine,
which is a Western African shrub, psychedelic. And then we have, so that's a plant, and then we have mescaline, which is also, it comes actually comes from a cactus. Interesting. And then there is psilocin, which I believe is a relative of psilocybin. So I assume that's kind of a relative of fungi, psilocybin. But so we are going to read this initiative out loud because the only state to legalize these plants and fungi drugs medicinally statewide is Oregon, and that was done, I think, a couple of election cycles ago, like the 2020 presidential election, I believe. And so this is I also looked up the people's names who represent this initiative. Their bios or resumes are not on LinkedIn. So I guess, okay, so their names are Veronica Perez. She's from Littleton, Colorado. And then Kevin Thomas Mathews, he resides in Arvada, Colorado. They are the designated representatives of this initiative. Again, I could not find them on LinkedIn. And so this is an initiative. So according to Ballot, an initiated date statute is an initiated ballot measure that amends statutes of the 26 states that provide some form of initiative. 21 states allow for citizens to initiate state statutes. Okay. There are a couple of different kinds of state statutes. I think this is the initiated state statute. Indirect initiated statutes do not go immediately to the ballot after successful. No, that's not it. So this is a direct initiated state statute. So this means that basically, if it gets enough signatures, this would be 120,000 signatures in Colorado. It goes to the ballot, and then I believe if we pass it, it cannot be overturned by the legislature. It can be overturned as if there is another ballot initiative created by 4 other people to overturn it or repeal it. And let's see here. I think that's it. So now we are going to read the whole ballot initiative. So basically, this is to legalize medicinally statewide, but also to decriminalize small amounts of possession and to legalize the sale of medicinal. It would also it would allow people to give away these substances substances as long as they're not selling them. In order for it to be sold, it would have to come from a professional, certified doctor or nurse or practitioner, whatever. So enough with me ranting about this. Let's just jump right into the whole thing. This is 18 pages long, the language of the initiative. So here we go. Again, please, would love for you to follow me on Twitter at Dolan Knapp. You can subscribe to my YouTube channel at Aurora Ideas. I'm also broadcasting live on Twitter and also Clubhouse. All right, so let's just jump right into it. Be it enacted by the people of the state of Colorado, Section 1, in Colorado Revised Statute, Article 170 to Title 12 as follows. The short title of this Article 170 is the Natural Medicine and Health Act. 12-170-102 Legislative Declaration. The voters of the state of Colorado find and declare that a Colorado's current approach to mental health. So I would actually support this measure because, first of all, I don't think that people should be put in jail for consuming an all-natural substance as long as they're not harming someone else. And we already have an issue with overcrowding of our prisons and jails. And if you put someone, I mean, if you have a criminal record, it's very hard to get a job, right? And it's hard to get a job anyway, even without a criminal record. So to be criminalizing people for this, it just kind of escalates the problems of finding a job, basically living your life the way you want to live it. I mean, if you have some kind of a criminal record, it's going to affect you permanently. And also, these substances have proven to show that they have therapeutic effects. So, like helping eradicate depression, anxiety, just feelings of just sadness. So also, like, at end of life, like basically if you're in a hospice and you have anxiety around death, taking psilocybin or these other plant-based substances can help you become at peace with that. So the voters of the state of Colorado find and declare that Colorado's current approach to mental health has failed its promise. Coloradans deserve more tools to address mental health issues, including approaches such as natural medicines that are grounded in treatment, recovery, health, and wellness, rather than criminalization, stigma, suffering, and punishment. So the other thing is that, like, in Denver, in the greater Denver area, there's an issue with veterans who are suffering from post-traumatic stress disorder. And so these substances have shown to help with PTSD. And also, if pharmaceuticals aren't working, it's nice to have an alternative to the pharmaceuticals. Coloradans are experiencing problematic mental health issues, including but not limited to suicide, addiction, depression, and anxiety. An extensive and growing body of research is advancing to support the efficacy of natural medicines combined with psychotherapy as treatment for depression, anxiety, substance use disorders, end-of-life distress, and other conditions. So basically, this would allow for a certified specialist to help do like a guided meditation with you in a therapy session. The federal government will take years to act, and Coloradans deserve the right to access natural medicines now. E. Natural medicines have been used safely for millennia by cultures for healing. Gosh, it's saying that I have a poor connection, but I hope it's there. G. The City and County of Denver voters enacted Ordinance 301 in May 2019 to make the adult's personal possession and use of the natural medicine psilocybin the lowest law enforcement priority in the City and County of Denver, and to prohibit the City and County from spending resources on enforcing release. Sir, decriminalize psilocybin in 2019. So basically, yeah, you don't, you're not, so basically, you may get a fine, maybe, but it wouldn't go on your criminal record. H. Oregon voters marijuana in Oregon in November 2020 to establish a regulated system of part to provide people access to psilocybin for their purposes. I. Criminalizing natural medicines. Criminalizing natural medicines has denied people from accessing accurate education and reduction information related to the use of natural medicines, and limited the development of appropriate training for first and multi responders, including law enforcement, emergency medical services, social services, and fire services. So this is a psychedelic just like marijuana, cannabis is, but it can cause some more intensities in the usage if you're not careful. You just have to make sure you have the right mindset going into it. You're in a comfortable environment. Whereas with marijuana, you don't really have to. Cannabis, you don't have to worry about being in the right mindset or being in the right environment, like in a safe space. So that's where you have to be careful with these types of substances, especially psilocybin mushrooms. J. The purpose of this Natural Medicine Health Act of 2022 is to establish a new, compassionate, and effective approach to natural medicines by I. Adopting a public health and harm reduction approach to natural medicines by removing criminal penalties for personal use for adults 21 years of age and older. 2. Developing and promoting public education related to the use of natural medicines and appropriate training for first responders. And 3. Establishing regulated access by adults 21 years of age and older to natural medicines that show promise in improving well-being, life satisfaction, and overall health. K. The provisions of Article I-70 shall be interpreted consistently with the findings and purposes stated in the section and shall not be limited by any Colorado law that could conflict with or be interpreted to conflict with the purposes and policy objectives stated in this section. L. The people of the state of Colorado further find and declare that it is necessary to ensure consistency and fairness in the application of Article 170 throughout the state, and that, therefore, the matters addressed by this Article 170 are, except as specified herein, matters of statewide concern. I'm just going to open up the window really quickly. It's getting kind of stuffy in here. 12-170-103 definitions. 1. As used in this Article 170, unless the context otherwise requires. A. Administration session means a session held at healing center or another location as permitted by rules adopted by the department at which a participant purchases, consumes, and experiences the effects of a natural medicine under the supervision of a facilitator. B. Department means the Department of Regulatory Agencies. C. Facilitator means a person licensed by the department who is 21 years of age or older. Hold on. 3, has agreed to provide natural medicine services to a participant. 3, has met the requirements established by the department. Oh yeah, I forgot to mention that I pinned the link at the top of the Colorado Secretary of State where you can access all the information on this ballot initiative. You can also go to ballotpedia.org to check out information about it as well. D, healing center means an entity licensed by the department that is organized and operated as a permitted organization. 1, that acquires, possesses, cultivates, manufactures, delivers, transfers, transports, supplies, sells, or dispenses natural medicine and related supplies, or provides natural medicine for natural medicine services at locations permitted by the department, or engages in 2 or more of these activities. 2, where administration sessions are held, or 3, where natural medicine services are provided by a facilitator. E, healthcare facility means a hospital, hospice, community mental health center, federally qualified health center, rural health clinic, PACE organization, long-term care facility, a continuing care retirement community, or other type of facility where healthcare is provided. F, integration session means a meeting between a participant and facilitator that occurs after the participant has completed an administration session. G, locality means a county, municipality, or city and county. H, natural medicine means the following substances in any form that would cause such plant or fungus to be described in the Uniform Controlled Substances Act of 2013, Article 18 of Title 18, dimethyltryptamine. Oh, that was another one that I forgot to mention was dimethyltryptamine, DMT, which is another plant-based substance. And then
ibogaine,
mescaline, or let's see,
mescaline,
excluding Lafafora, William Z. peyote, psilocybin, and psilocin. That's the fungi coming from the mushroom. Psilocin. Not sure what the difference is between psilocybin and psilocin. I, natural medicine services means services provided by a facilitator or other authorized person to participate before, during, and after the participant's consumption of natural medicine, including at a minimum at 1, a preparation session, 2, an administration session, and 3, an integration session. J, participant means a person 21 years of age or older who receives natural medicine services. K, permitted organization means any legal entity registered and qualified to do business in the state of Colorado that meets the standards set by the department under section 12-170-104. I, preparation session means a meeting between a participant and a facilitator that occurs before the participant participates in the administration session. 12-170-104, Regulated Natural Medicine Access Program. 1, the Regulated Natural Medicine Access Program is established, and the department shall regulate the manufacture, cultivation, testing, storage, transfer, transport, delivery, sale, and purchase on natural medicines by and between healing centers and other permitting entities, and the provision of natural medicine services to participants. 2, not later than January 1st, 2024, the department shall adopt rules to establish the qualifications, education, and training requirements that facilitators must meet prior to providing natural medicine services, and to approve any required training programs. 3, not later than September 30th, 2024, the department shall adopt rules necessary to implement the Regulated Natural Medicine Access Program and shall begin accepting applications for licensure by that date, with decisions made on all licensing applications within 60 days of receiving the application. For purposes of the regulated natural medicine access program set forth in this section, A, until June 1st, 2026, the term natural medicine shall only include psilocybin and psilocin. Oh, that's interesting. B, after June 1st, 2026, if recommended by the Natural Medicine Advisory Board, the department may add one or more of the following to the term natural medicine: dimethyltryptamine, ibogaine, mescaline, and I think dimethyltryptamine. Yep. C, the department may prepare proposed rules for the addition of dimethyltryptamine, ibogaine, mescaline to the term natural medicine prior to June 1st, 2026. In the event that dimethyltryptamine, ibogaine, or mescaline, is it? Gosh, these words are crazy.
Mescaline.
Yeah, mescaline. Mescaline, excluding the 4,4 Williams I POD, is added to the term natural medicine under subsection 4B of this section. 5. In carrying out its duties under the Article 170, the department shall consult with the Natural Medicine Advisory Board and may also consult with other state agencies or any other individual or entity the department finds necessary. 6. The rules adopted by the department shall include, but are not limited to, rules to A, establish the requirements governing the safe provision of natural medicine services to participants that include 1. Holding and verifying completion of a preparation session, an administration session, and integration session. 2. Health and safety warnings that must be provided to participants before natural medicine services begin. 3. Educational materials that must be provided to participants before natural medicine services begin. 4. The form that each facilitator, participant, and authorized representative of a healing center must sign before providing or receiving natural medicine services, verifying that the participant was provided accurate and complete health information and informed of identified risk factors and contradictions. 5. Proper supervision during the administration session and safe transportation for the participant when the session is complete. 6. Provisions for group administration sessions where one or more facilitators provide natural medicine services to more than one participant as part of the same administration session. 7. Provisions to allow a facilitator or a healing center to refuse to provide natural medicine services to a participant. 8. The requirements and standards for independent testing of natural medicine for concentration and contaminants to the extent available technology reasonably permits. 9. The licensure of entities permitted to engage in the testing of natural medicine for use in natural medicine services or otherwise. 10. The standards for advertising and marketing natural medicine and natural medicine services. 11. The standards for qualification as a permitted organization addressing without limitation environmental, social, and governance criteria directed to the findings and declarations stayed forth in Section 12-170-102. B. Establish the requirements governing the licensing and practice of facilitators that include 1. The form and content of license and renewal applications for facilitators submitted under the Article 170. 2. The qualifications, education, and training requirements that facilitators must meet prior to providing natural medicine services. The requirements shall A. be tiered so as to require varying levels of education and training depending on the participants the facilitator will be working with and the services the facilitator will be providing. B. Include education and training on client safety, contraindications, mental health, mental state, physical health, physical state, social and cultural considerations, physical environment, preparation, integration, and ethics. C, allow for limited waivers of education and training requirements based on an applicant prior experience, training, or skill, including but not limited to with natural medicines. D, not impose unreasonable financial or logistical barriers that make obtaining a facilitator license commercially unreasonable for low income people or other applicants. E, not require a professional license or professional degree other than a facilitator license granted pursuant to this section. F, allow for paid compensation for natural medicine services. G, allow for the provision of natural medicine services to more than one participant at a time in a group administration session. 3, oversight and supervision requirements for facilitators, including professional responsibility standards and continuing education requirements. 4, a complaint review and disciplinary process for facilitators who engage in misconduct. 5, sorry, this is all in Roman numerals, so it's kind of annoying. 5, record keeping, privacy, and confidentiality requirements for facilitators, provided such record keeping does not result in the disclosure to the public or any government agency of personal identifiable information of participants. 6, procedures for suspending or revoking the licenses of facilitators who violate the provisions of this Article 170 or the rules adopted by the department. C, establish the requirements governing the licensing and operation of healing centers that include 1, qualifications for licensure and renewal. 2, oversight requirements for healing centers. 3, record keeping, privacy, and confidentiality requirements for healing centers, provided such record keeping does not result in the disclosure to the public or any government agency of personally identifiable information of participants. 4, security requirements for healing centers, including requirements for protection of each licensed healing center location by a fully operational security alarm system. 5, procedures for suspending or revoking the licensing of healing centers that violate the provisions of Article 170 or the rules adopted by the department. 6, permissible financial relationships between licensed healing centers, facilitators, and other entities. 7, procedures and policies that allow for healing centers to receive payments for services and natural medicines provided. 8, procedures and policies to ensure statewide access to healing centers and natural medicine services. 9, rules that prohibit an individual from having a financial interest in more than 5 healing centers. 10, rules that allow for healing centers to share the same premises with other healing centers or to share the same premises with healthcare facilities. Rules that allow 11, rules that allow for locations not owned by a healing center where natural medicine services may be provided by licensed facilitators, including but not limited to healthcare facilities and private policies and programs to ensure the regulatory access program is equitable and inclusive, and to promote the licensing of and the provision of natural medicine services to persons from communities that have been disproportionately harmed by high rates of controlled substances arrests, to persons who face barriers to access to healthcare, to persons who have a traditional or indigenous history with natural medicines, or to persons who are veterans that include but are not limited to 1, reduced fees for licensure and facilitator training. 2, incentivizing the provision of natural medicine services at a reduced cost to low-income individuals. 3, incentivizing geographic and cultural diversity in licensing in the provision and availability of natural medicine services. 4, a process for annually reviewing the effectiveness of such policies and programs promulgated under the subsection 6D. E, establish application, licensing, and renewal fees for the Healing Center and facilitator licenses. The fees shall be 1, sufficient, but shall not exceed the amount necessary to cover the cost of administering the Regulated Natural Medicine Access Program, including the Regulated Natural Medicine Access Program Fund in 12-170-106. 2, for licensing and renewal fees scaled based on either the volume of business of the licensee or the gross annual revenue of the licensee. F, develop and promote accurate public education campaigns related to the use of natural medicine, including but not limited to the public service announcements, educational curricula, and appropriate crisis response, and appropriate training for first and multi-responders, including law enforcement, emergency medical services, social services, and fire services. G, study and deliver recommendations to the legislature regarding the regulation of dosage for the off-site use of natural medicines. H, collect and annually publish data on the implementation and outcomes of the Regulated Natural Medicine Access Program in accordance with good data and privacy practices, and that does not disclose any identifying information about individual licensees or participants. I, adopt, amend, and repeal rules as necessary to implement the Regulated Natural Medicine Access Program and to protect the public health and safety. 7, participant records collected and maintained by healing centers, facilitators, registered entities, or the department shall constitute medical data as defined by Section 24-72-2043AI and are not public records subject to disclosure. A, the department shall have the authority to create and issue any additional types of licenses and registrations it deems necessary to carry out the intents and purposes of the Regulated Natural Medicine Access Program, including allowing natural medicine services to be provided at other types of licensed health facilities or by individuals in order to increase access to and the availability of natural medicine services. 9, the department shall have the authority to adopt rules that differentiate between natural medicines and that regulate each natural medicine differently based on its specific qualities, traditional uses, and safety profile. 10, the department shall adopt, amend, and repeal all rules in accordance with the State Administrative Procedure Act, Article 4, Title 24 CRS as amended, and the rules promulgated thereunder. 12-170-105, Natural Medicine Advisory Board. The Natural Medicine Advisory Board shall be established within the department for the purpose of advising the department as to the implementation of the Regulated Natural Medicine Access Program. 2, the board shall consist of 15 members. Members shall be appointed by the governor with the consent of the Senate. 3, members of the initial board shall be appointed by January 1st, 2023. In making the appointments, the government shall appoint A, at least 7 members with significant expertise and experience in one or more of the following areas: natural medicine, therapy, medicine and research, mycology, which I'm not sure what that is, and natural medicine cultivation, permitted organization criteria, emergency medical services, and services provided by first responders, mental and behavioral health providers, health care insurance and health care policy, and public health, drug policy, and harm reduction. B, at least 8 members with significant experience in one or more of the following areas: religious use of natural medicines, issues confronting veterans, traditional indigenous use of natural medicines, levels and disparities in access to healthcare services among different communities, and past criminal justice reform efforts in Colorado. At least one of the 8 members shall have expertise or experience in traditional indigenous use of natural medicines. 4, for the initial board, 7 of the members shall be appointed to a term of 2 years and 8 members shall be appointed to a term of 4 years. Each member appointed thereafter shall be appointed to a term of 4 years. Members of the board may serve up to 2 consecutive terms. Members are subject to removal as provided in Article 5 Section 6 of the Colorado Constitution. 5. Not later than September 30th, 2023, and annually thereafter, the board shall make recommendations to the department related to, but not limited to, all the following areas. A. Accurate public health approaches regarding use, effect, and risk reduction for natural medicine in the content and scope of educational campaigns related to natural medicine. B. Research related to the efficacy and regulation of natural medicine, including recommendations related to product safety, harm reduction, and cultural responsibility. C. The proper content of training programs, educational and experiential requirements and qualifications for facilitators. D. Affordable, equitable, ethical, and cultural responsibility access to natural medicine and requirements to ensure that the regulated natural medicine access program is equitable and inclusive. E. Appropriate regulatory considerations for each natural medicine. F. The condition of natural medicines to the regulated natural medicine access program under Section 12-170-104 4B based on available medical, psychological, and scientific studies, research, and other information related to the safety and efficacy of each natural medicine. All rules to be promulgated by the department under 12-170-104, and H. Requirements for accurate and complete data collection, reporting, and publication of information related to the implementation of this Article 170. 6. The board shall, on an ongoing basis, review and evaluate existing research, studies, and real-world data related to natural medicine and make recommendations to the legislature and other relevant state agencies as to whether natural medicine and associated services should be covered under Health First Colorado or the insurance programs as a cost-effective intervention for various mental health conditions, including but not limited to the end-of-life anxiety, substance use disorder, alcoholism, depressive disorders, neurological disorders, cluster headaches, and post-traumatic stress disorder. 7. The board shall, on an ongoing basis, review and evaluate sustainability issues related to natural medicine and impact on indigenous cultures and document existing reciprocity efforts and continuing support measures that are needed as part of its annual report. 8. The board shall publish an annual report describing its activities, including the recommendations and advice provided to the department and the legislature. 9. The department shall provide requested technical, logistical, and other support to the board to assist the board with its duties and obligations. 10. The section is repealed effective December 31st, 2023. 12- this section is repealed December 31st, 2033. Okay, so it looks like there's kind of a sunset here. 2033. 12-170-106 Regulated Natural Medicine Access Program Fund. The Regulated Natural Medicine Access Program Fund, hereby created in the State Treasury. The fund is administered by the department and consists of all money from fees collected and money transferred from the general fund under this Article 170. All interest and income earned on the deposit and investment of money in the fund shall be credited to the fund and shall not be transferred to the general fund or any other state fund at the end of any state fiscal year. Okay, so they're creating a fund administered by the department and consists of all money from, okay. 2, the department may seek, accept, and expend any gifts, grants, donations, loans, loan of funds, property, or any other revenue or aid in any form from the state, any state agency, and other public source, any private source, or any combination thereof, and any such monetary receipt shall be credited to the fund, and any such in-kind receipts shall be applied for the benefit of the fund. The money in the fund is continually appropriated to the department for the direct and indirect costs of carrying out the provisions of this Article 170. 4. Funds for the initial establishment and support of the regulatory activities by the department under this Article 170 including the Natural Medicine Advisory Board, the development and promotion of public education campaigns related to the use of natural medicine, and the development of the policies, procedures, and programs required by 12-170-1046D shall be advanced from the general fund and to the regulated Natural Medicine Access Program Fund and shall be repaid to the general fund by the initial proceeds from fees collected pursuant to the Article 170. 5. The Office of the State Planning and Budget shall determine the amount of the initial advance from the general fund to the regulated Natural Medicine Access Program Fund based on the estimated cost of establishing the program. 12-170-107 Localities. A locality may regulate the time, place, and manner of the operation of the healing centers licensed pursuant to this Article 170 within its boundaries. 2. A locality may not ban or completely prohibit the establishment or operation of healing centers licensed pursuant to this Article 170 within its boundaries. 3. A locality may not ban or completely prohibit a licensed healthcare facility or individual within its boundaries from providing natural medicine services if the licensed healthcare facility or individual is permitted to provide natural medicine services by the department pursuant to this Article 170. Okay. 4. A locality may not prohibit the transportation of natural medicine through its jurisdiction on public roads by a licensee or as otherwise allowed by this Article 170. 5. A locality may not adopt ordinances or regulations that are unreasonable or in conflict with this Article 170, but may enact laws imposing lesser criminal or civil penalties than provided by this Article 170. 12-170-108 Protections. 1. Subject to the limitations in this Article 170, but notwithstanding any other provision of law. A. Actions and conduct permitted pursuant to a license or a registration issued by the department or by department rule or by those who allow property to be used pursuant to a license or registration issued by the department or by department rule are not unlawful and shall not be an offense under state law or the laws of any locality within the state or be subject to a civil fine, penalty, or sanction, or be a basis for definition, search, or arrest, or to deny any right or privilege, or to seize or forfeit assets under state law or the laws of any locality within the state. B. A contract is not unenforceable on the basis that natural medicines as allowed under this Article 170 are prohibited by federal law. C. A holder of a professional or occupational license, certification, or registration is not subject to professional discipline or loss of a professional license or certification for providing advice for services arising out of or related to natural medicine licenses. Applications for licenses on the basis that natural medicines are prohibited by federal law or for personal use of the natural medicines as allowed under the Article 170. This section does not permit a person to engage in malpractice. D. Mental health, substance use disorder, or behavioral health services otherwise covered under the Colorado Medical Assistance Act. Articles 4 to 6 of the Title 25.5 CRS shall not be denied on the basis that they are covered in conjunction with natural medicine services or that natural medicines are prohibited by federal law. No insurance or insurance provided is required to cover the cost of the natural medicine itself. E. Nothing in this section shall be construed or interpreted to prevent the department from enforcing its rules against a license or to limit a state or local law enforcement agency's ability to investigate unlawful activity in relation to a license. 12-170-109 Personal use. 1. Subject to the limitations in this Article 170, but notwithstanding any other provisions of law, the following acts are not an offense under state law or the laws of any locality within the state or subject to a civil fine, penalty, or sanction, or the basis for detention, search, or arrest, or to deny any right or privilege, or to seize or forfeit assets under state law or the laws of any locality if the person is 21 years of age or older. A. Possessing, storing, using, processing, transporting, purchasing, obtaining, or ingesting natural medicine for personal use, or giving away natural medicine for personal use without remuneration to a person or persons 21 years of age or older. B. Growing, cultivating, or processing plants or fungi capable of producing natural medicine for personal use if 1. The plants and fungi are kept in or on the grounds of a private home or residence, and 2. The plants and fungi are secured from access by persons under 21 years of age. C. Assisting another person or persons who are 21 years of age or older, or allowing property to be used in any of the actions or conduct permitted under subsection 1. 2. For the purpose of the Article 170, personal use means the personal ingestion or use of a natural medicine and includes the amount a person may cultivate or possess of natural medicine necessary to share natural medicines with other persons 21 years of age or older within the context of counseling, spiritual guidance, beneficial community-based use and healing, supported use or related services. Personal use does not include the sale of natural medicines for remuneration. 3. Conduct permitted by the Article 170 shall not by itself A. Constitute child abuse or neglect without a finding of actual threat to the health or welfare of a child based on all relevant factors. B. The basis to restrict parenting time with a child without finding that the parenting time would endanger the child's physical health or significantly impair the child's emotional development. 4. Conduct permitted by this Article 170 shall not by itself be the basis for punishing or otherwise penalizing a person currently under parole, probation, or other state supervision or released awaiting trial or other hearing. 5. Conduct permitted by this Article 170 shall not by itself be the basis for the definition, search, or arrest, and the possession or suspicion of possession of a natural medicine or the possession of multiple containers of natural medicine shall not individually or in combination with each other constitute reasonably articulable suspicion of a crime. Natural medicines as permitted by the Article 170 are not contraband nor subject to seizure and shall not be harmed or destroyed. 6. Conduct permitted by this Article 170 shall not by itself be the basis to deny eligibility for any public assistance program unless required by federal law. 7. For the purposes of medical care, including organ transplants, conduct permitted by this Article 170 does not constitute the use of an illicit substance or otherwise disqualify a person from medical care or medical insurance. 8. Nothing in this section shall be construed or interpreted to permit a person to give away any amount of natural medicine as part of a business promotion or other commercial activity, or to permit paid advertising related to the natural medicine sharing of natural medicine or services intended to be used concurrently with a person's consumption of natural medicine. Such advertising may be considered evidence of commercial activity that is prohibited under this section. This provision does not preclude the donation of natural medicine by a person 21 years of age or older, payment for bona fide harm reduction services, bona fide therapy services, or other bona fide support services. Maintaining personal or professional websites related to natural medicine services, the dissemination of educational materials related to natural medicine or limited to the ability of a healing center to donate natural medicine or provide natural medicine at reduced cost consistent with department rules. 9. A person who has completed a sentencing for conviction, whether by trial or plea of whether by trial or plea of guilty or nolo contendere I'm gonna have to look that term up because I'm not sure what that means. Nolo condendere. Just copy and paste it. Control copy. Google. What the heck does that mean?
Nolo contendere.
Nolo contendere, a plea by which a defendant in a criminal prosecution accepts conviction as though a guilty plea had been entered but does not admit guilt. Okay. Who would not have been guilty of an offense under this act had it been in effect at the time of the offense, may file a petition before the trial court that entered the judgment of conviction in the person's case to seal the record of the conviction at no cost. If there is no objection from the district attorney, the court shall automatically seal such record. If there is an objection by the district attorney, a hearing shall be held and the court shall determine if the prior conviction does not qualify to be sealed under the act. If the record does not qualify to be sealed, the court shall deny the sealing of the record. Nothing in this section shall be construed to diminish or abrogate any rights or remedies otherwise available to the petitioner or applicant. 12-170-110, personal use penalties. Unless otherwise provided by subsection 2 of this section, a person who is under 21 years of age is subject to a drug petty offense, and upon conviction thereof shall be subject only to a penalty of no more than 4 hours of drug education of counseling provided at no cost to the person if the person A, possesses, uses, ingests, inhales, or transports natural medicine for personal use. B, gives away without remuneration natural medicine for personal use. C, possesses, uses, or gives away without remuneration natural medicine paraphernalia. 2, to the extent subsection 1 establishes a penalty for conduct not otherwise prohibited by law or establishes a penalty that is greater than exists elsewhere in law for the conduct set forth in subsection 1, the penalties in subsection 1 shall not apply. 3, a person who cultivates natural medicines that are not secure from access by a person under 21 years of age in violation of 12-170-109 1B is subject to a civil fine not exceeding $250 in addition. 4, a person shall not be subject to any additional fees, fines, or other penalties for the violations addressed in this section other than those set forth in this section. Further, a person shall not be subject to increased punishment for any other crime on the basis of that person having undertaken conduct permitted by this Article 170. 12-170-111 limitations. 1. This Article 170 shall not be construed A, to permit a person to drive or operate a motor vehicle, boat, vessel, aircraft, or other device that is capable of moving itself or of being moved from place to place upon wheels or endless tracks under the influence of natural medicine. B, to permit a person to use or possess natural medicine in a school, detention facility, or public building. C, to permit a person to ingest natural medicines in a public place other than a place licensed or otherwise permitted by the department for such use. D, to permit the transfer of natural medicine with or without remuneration. Okay, this word keeps popping up. I'm going to look it up because it's starting to bother me. Control copy. How do you pronounce it?
Remuneration.
Remuneration. Money paid for work or a service. Remuneration to a person under 21 years of age or to allow a person under 21 years of age to use or possess natural medicine. E, to permit a person to engage in conduct that endangers or harms others. F, to require a government medical assistance program or private health insurer to reimburse a person for costs of purchasing natural medicine. G, to require an employer to permit or accommodate the use, consumption, possession, transfer, display, transportation, or growing of natural medicines in the workplace. H, to prohibit a recipient of a federal grant or an applicant for a federal grant from prohibiting the use, consumption, possession, transfer, display, transportation, or growing of natural medicines to the extent necessary to satisfy federal requirements for the grant. I, to prohibit a party to a federal contract or a person applying to be a party to a federal contract from prohibiting any act permitted to this Article 170 to the extent necessary to comply with the terms and conditions of the contract or to satisfy federal requirements for the contract. J, to require a person to violate federal law, or K, to exempt a person from a federal law or obstruct the enforcement of a federal law. 12-170-112, liberal construction. This act shall be liberally construed to effectuate its purpose. 12-170-113, preemption. No locality shall adopt, enact, or enforce any ordinance, rule, or resolution imposing any greater criminal or civil penalty than provided by this act, or that is otherwise in conflict with the provisions of this act. A locality may enact laws imposing lesser criminal or civil penalties that provided by this act. 12-170-114, self-executing severability, conflicting provisions. All provisions of this Article 170 are self-executing, except as specified herein are severable, and except where otherwise indicated in the text shall supersede conflicting state, statutory, local charter ordinance or resolution, and other state and local provisions. If any provision of this act or its application to any person or circumstance is held invalid, the invalidity does not affect other provisions or applications of this act that can be given effect without the invalid provision or application, and to this end, the provisions of this act are severable. 12-170-115, effective date. Unless otherwise provided by this act, all provisions of this act shall become effective upon the earlier the official declaration of the vote herein by proclamation of the governor, or 30 days after the vote has been canvassed, pursuant to Section 1(4) of Article 5 of the Colorado Constitution. The removal and reduction of criminal penalties by this act is intended to have retroactive effect. I think it's actually Article 4. I don't know. It's using Roman numerals. Not good with Roman numerals. Section 2. In Colorado Revised Statutes 18-18-403.5, amend 1 as follows. 18-18-403.5, unlawful possession of a controlled substance. 1, except as authorized by Part 1 or 3 of Article 280 of Title 12, Part 2 of Article 80 of Title 27, Section 18-1-711, Section 18-18-428-1B, and they cross out or Part 2 or 3 of this Article 18 or the Natural Medicine Health Act 2022, Article 170 of Title 12. It is unlawful for a person knowingly to possess a controlled substance. Section 3 in Colorado Revised Statutes 18-18-404, amend 1A as follows. 18-18-404, unlawful use of controlled substance. 1A, except as is otherwise provided for offenses concerning marijuana and marijuana concentrate in sections 18-18-406 and 18-18-406.5, or by the Natural Medicine Health Act of 2022, Article 170, or of Title 12, any person who uses any controlled substance except when it is dispensed by or under the direction of a person licensed or authorized by law to prescribe, administer, or dispense the controlled substance for bona fide medical needs, commits a level 2 drug misdemeanor. Section 4 in Colorado Revised Statutes 18-18-405 amend 1A as follows. 18-18-405-405 unlawful distribution, manufacturing, dispensing, or sale 1A except as authorized by Part 1 of Article 280 of Title 12, Part 2 of Article 80 of Title 27 crosses out or Part 2 or 3 of this Article 18 or by the Natural Medicine Health Act of 2022. Article 170 of Title 12, it is unlawful for any person knowingly to manufacture, dispense, sell, or distribute, or to possess with intent to manufacture, dispense, sell, or distribute a controlled substance or attempt to induce or conspire with one or more other persons to manufacture, dispense, sell, distribute, or possess with intent to manufacture, dispense, sell, or distribute a controlled substance or possess one or more chemicals or supplies or equipment with the intent of manufacture or a controlled substance. Section 5 in Colorado Revised Statutes amend 18-18-410 as follows. 18-18-410 Declaration of Class 1 Public Nuisance, except as permitted by the Natural Medicine Health Act of 2022. Article 170 of Title 12, any store, shop, warehouse, dwelling house, building, vehicle, boat, or aircraft, or any place whatsoever which is frequented by controlled substance addicts for the unlawful use of controlled substances or which is used for the unlawful storage, manufacture, sale, or distribution of controlled substances is declared to be a Class 1 public nuisance and subject to the provisions of Section 16-13-303 CRS. Any real or personal property which is seized or confiscated as a result of an action to abate a public nuisance shall be disposed of pursuant to Part 7 of Article 13 of Title 16 CRS. Section 6. In Colorado Revised Statutes 18-18-411 add 5 as follows. 18-18-411 keeping, maintaining, controlling, renting, or making available property for unlawful distribution or manufacture of controlled substances. 5. A person acting in compliance with the Natural Medicine Health Act of 2022, Article 170 of Title 12 does not violate this section. Section 7 in Colorado Revised Statutes 18-18-412.7 add 3 as follows. 18-18-412.7 sale or distribution of materials to manufacture and controlled substances. A person acting in compliance with the Natural Medicine Health Act of 2022, Article 170 of Title 12 does not violate this section. Section 8 in Colorado Revised Statutes 18-18-430.5 and 1C as follows. 18-18-430.5 drug paraphernalia exemption. 1A person is exempt from sections 18-18-425 to 18-18-430 if the person is using equipment, products, or materials in compliance with the Natural Medicine Health Act of 2022, Article 170 of Title 12. The manufacture, possession, and distribution of such equipment, products, or materials shall be authorized within the meaning of 21 USC 863 Section F. Section 9 in Colorado Revised Statute 16-13-303 add 9 as follows. 16-13-303 Class 1 Public Nuisance. 9A, person acting in compliance with the Natural Medicine Health Act 2022, Article 170 of Title 12 does not violate this section. Section 10 in Colorado Revised Statute 16-13-304 add 2 as follows. 16-13-304 Class 2 Public Nuisance. 2. A person acting in compliance with the Natural Medicine Health Act 2022, Article 170 of Title 12 does not violate this section. Okay, so that's the whole thing. Lots of sections that you have to refer to, but yeah, it looks as though it's on the ballot, so we'll have to see if it gets passed. Again, Oregon's the only other state that's passed it medicinally and decriminalized. But yeah, it seems to me that there's no reason why this shouldn't pass. And I mean, there are many benefits to these psychedelics, but we just have to be careful. And why should someone go to jail for just possessing, or not even like, yeah, if they're selling it, then, you know, they're not licensed to sell, then that should be a problem. But other than that, I mean, I've taken psilocybin mushrooms a few times in my life, and one of the times I took it, it was the best time I've ever had in my life, literally. So it really has some major, if you just do the research, just Google it, it can really change lives. And the great thing about these psychedelics, at least with psilocybin, is that you only have to take it 1 or 2 times for it to have a lifelong effect. It's not as nearly as dangerous as alcohol, that's for sure. I mean, look at alcohol. Like many people die from drinking and driving every day. Thousands of people every day, I would assume, worldwide, maybe, or thousands of people yearly. And it's kind of like marijuana. Like you can't. It's really hard to overdose on it. Um, so yeah, that's pretty much it. Glad we got through it. I've been having connection problems all day, but there you go. So we'll check back in probably at some point to give you an update as to whether or not it passed. But hope everyone has a good day, and cheers.